Convicted trafficker and accomplice to Jeffrey Epstein, Ghislaine Maxwell, is taking her case to the United States Supreme Court, and she is now asking the justices to throw out her 20-year sentence and let her out of prison right now. And what's interesting here is Maxwell isn't asking the justices to throw out her conviction because she's innocent. Today, she filed another petition asking the justices to settle an argument over whether the U.S. government is required to honor its commitments nationwide. And if the justices agree with her argument, then Maxwell's conviction could be thrown out. So here's what's going on. Ghislaine Maxwell was convicted on several federal charges back in 2021, and she's been appealing ever since. Her argument is that she should never have been prosecuted in the first place. Again, not because she's innocent, but because of a sweetheart deal that the U.S. Attorney in the Southern District of Florida offered to Jeffrey Epstein back in 2007. That deal said if Epstein pleaded guilty to lesser state charges, he would not be prosecuted for the more serious federal crimes the FBI said he committed between 2001 and 2007, and he would serve a sentence of a little more than a year on a work release program. The U.S. Attorney for the Southern District of Florida who cut this sweetheart deal with Jeffrey Epstein was a man by the name of Alex Acosta, who later became President Trump's labor secretary during his first term. Well, now Ghislaine Maxwell says there was one line in that sweetheart deal that Acosta gave Epstein, which should have protected her. The non-prosecution agreement said, as long as Jeffrey Epstein pleaded guilty to those state crimes and served out his sentence, which he did, the United States also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to the four named individuals. By the way, Maxwell was not one of those four named individuals, but she says she could have been considered a co-conspirator, so she should not have been charged. Obviously, that deal did not protect Maxwell, and instead she was charged by the federal government and convicted in the Southern District of New York for very serious federal crimes. The Southern District of New York is not the Southern District of Florida, right? Those are two different places. And the feds say that non-prosecution agreement Epstein signed was a bad move by Acosta, where he showed bad judgment. But it doesn't say anything about New York, nor does it say anything about the crimes the federal government says Maxwell committed between 1994 and 2004. The government said their prosecution of Maxwell was totally legit, and the Second Circuit Court of Appeals agreed, saying plea deals only bind the office and the district where they are made, and in the eyes of the Second Circuit, that Florida non-prosecution agreement is irrelevant in the state of New York. Now, here's where the Supreme Court comes in. Yeah, the Second Circuit Court of Appeals may believe that, but not all appeals courts in this country agree with that stance. Others believe if one U.S. attorney in his or her capacity representing the U.S. government makes a deal, unless it's otherwise stated in that deal, it should apply to the whole U.S. government throughout the entire country. And that's what's called a split issue. And that split is the hook Maxwell is hoping the justices will bite on. She wants the justices to decide once and for all how far those plea deals can reach and whether they should apply to the entire country. Usually when there's a split issue among the appeals courts on a legal question, that's something the justices normally want to weigh in on. But on the other side, this case is such a political hot potato, it's unclear whether the justices are going to want to touch it with a 10-foot pole. We'll know for sure whether they're going to take Ghislaine Maxwell's case when the justices return from their summer recess and begin their next term in October.